Jodi Balsam joins us now, professor at Brooklyn Law School. It's great to see you, Jodi. This has been a remarkable day in our game. And, of course, the statement about this merger, one of the big, bold letters is that it ends litigation. What should we know, first of all, about that?
Well, it ends the litigation contingent on the merger agreement being finalized. What's interesting about this conclusion to the litigation is that PIF and LIV Golf are not receiving any of the relief that they identified in their complaint. They're not receiving any damages. They're not receiving any injunctive relief, stopping the PGA Tour from operating in the way that they objected to. What they are receiving and what performs as a settlement agreement is this merger. It's basically a one-way payment from PIF to the PGA Tour, as opposed to what you'd expect in an antitrust litigation settlement and payment in the other direction. But of course, PIF is getting a lot of value in return, right? PIF is getting to latch on to the legacy, the reputation, the history, the structure of the PGA Tour in this new merged entity.
The discovery process was something that we had discussed with you multiple times here on Golf Channel. With the recent ruling that had occurred yesterday, do you think that propelled us to where we are now?
Well, the ruling yesterday would have delayed an ultimate decision on whether the Saudi entities were subject to the U.S. court's jurisdiction. It was a ruling that said the Ninth Circuit wants to take the full appellate briefing process to decide that issue, which could have lasted up to a year. But interestingly, what the new merged entities' proposed structure seems to indicate, especially with Yasser Al-Rumayyan serving as its chairman of the board, is a concession that PIF does in fact control LIV, that these Saudi entities are in fact engaged in commercial activity in the United States. So this litigation may be over, but how can the Saudis insulate themselves from U.S. court jurisdiction going forward, at least with respect to any litigation that might involve this new commercial entity?
Jodi, the thought process was that maybe the Saudis would not want information, relationships revealed in discovery. Is it possible that the PGA Tour similarly would not want to have their relationships potentially with sponsors dealing with the Saudi Arabian government revealed as well in discovery?
Discovery is a burden in many ways on parties involved, especially in antitrust litigation, which opens up all facets of an industry and a business's operations to disclosure. It's time-consuming, it's expensive, it's distracting. Nobody enjoys participating in high-level antitrust litigation discovery. So that was certainly one motivation for settling. But the antitrust concerns are not resolved here. One thing to point out is that this merger creates a single dominant presenter of elite golf. As Jay Monahan and Yasser Al-Rumayyan themselves described it earlier today, they are creating a global entity of golf. And remember that it's not just the DP Tour, LIV Golf, and the PGA Tour that are being consolidated, because the PGA Tour controls half a dozen other tours, including Canada and Latin America, and the Saudis are investors in the Middle Eastern North African Tour and in the Asian Tour. What are regulators, what are antitrust regulators going to make of this colossus? And remember, in the past, when competing leagues in a particular sport have attempted to merge, antitrust concerns were prevalent. In fact, the NFL and the AFL merger in the 1960s required an act of Congress to avoid antitrust disruption.
Any gauge of timeline for that vetting process to ensure that this merger, assuming the memorandum of understanding goes through among these three parties, for it to be proved domestically?
Well, we already know that the Department of Justice, the U.S. DOJ, has some interest in how the PGA Tour operates. Right? They were already investigating PGA Tour restraints on the labor market for golfers. That investigation is ongoing. They're already revved up to expand it if necessary. When we see the merger agreement, which the parties have promised us in a matter of weeks, that will be subject to DOJ review, and they may well require that the merger agreement be restructured in a way that is more market-friendly, more consumer-friendly. One of the things that the parties have going for them is what this merger does achieve is a reunification of elite golfers so that they compete together in tournaments in which the consumer gets the best possible golf product. So in that way, this merger is arguably consumer-friendly. But I think there still will be reservations, not only on the part of U.S. antitrust regulators, but in also the European Union competition law regulators and the U.K.
Jodi, from where we sit, we are shocked for the most part collectively about this development today. From your seat as a professor of law, as an attorney, how shocking is this proposal between groups that were, at loggerheads minutes ago?
Well, I will tell you from my experience as an antitrust litigator, this is frankly exactly what one would expect. Antitrust lawsuits are more often settled than tried, and often through an agreement between the parties that itself can raise antitrust concerns, right? What we've got now are three of the largest competitors, most elite competitors and providers of professional golf, agreeing essentially to create a cartel and move forward as a unified entity, which can pose anti-competitive obstacles to, for example, those who do business with them. How is this going to affect broadcasters who seek to purchase the rights to televise golf tournaments? They're now not dealing with multiple entities with some element of competition in rights, in setting rights fees. There's now one monolithic entity who will set a rights fee by dictate. So this is not unusual in terms of how these litigations go. The parties ultimately have to decide whether they're willing to change their business models entirely with the stick of an injunctive order coming down from a court, or to do so through cooperation. And these parties chose cooperation.
Jodi, this could have been a precedented case, antitrust case. Is that no longer the possibility now?
Well, in terms of setting precedent, there have been no significant judicial rulings on the merits in this case to set any kind of precedent going forward, other than the court's initial ruling way back in August when the lawsuit was first filed, and 11 golfers were the plaintiffs, and some of them sought injunctive relief to force the PGA to allow them to play in last year's FedEx Cup. And the PGA regulation at issue there was its exclusivity requirements that demanded that members of the PGA Tour not play for competing circuits unless they received a waiver. So going forward, that precedent that the judge set there, holding that the PGA's exclusivity requirements in that setting were not sufficiently anti-competitive to merit an early injunction, that precedent does inform some of what we'll see in the upcoming merger agreement, right? We have a court saying it's okay to continue to have exclusivity requirements, and I doubt that rule will change in the merged entity. We will still see golfers subject to tournament regulations that limit their access to competing in non-family tournaments, right? Tournaments that are sponsored by events outside of this new LIV PGA DP family. And we now have a judicial decision that says those sorts of restrictions can survive antitrust scrutiny.